Mr. Counsel, your only case is that he was not aware that what he had delivered was the drugs, the heroin, correct?
Yes, my lord.
That's your only case.
Yes.
How many cases have you done NDPS?
Here only this, my lord.
What about in the trial court? In the
Trial court.
you have got a few cases.
Yes.
There are many issues that are here. You have not taken up those issues, so it becomes slightly difficult. There are many issues.
My lord, in that case, if I may be allowed to do some another research, then.
He doesn't know what to do. Okay, we'll leave it like this. We'll see. We'll think about it. You know? Because there are many issues. You see, I don't feel like there are a lot of things that can be gone into. Whether there's any finding by the trial court, that is a very big issue. There has to be a finding. There is evidence, and there has to be a finding. Is there any finding? Anyway,
On the last quoted also, my lord, I already raised it. Since in the judgment it was, there's no proper finding according to raised.
okay, we'll see. I was hoping that you could add some more thing, but anyway.
Daily cost list, item number 1.
Maybe, Your Lordship. My Lord, I have received the instruction yesterday in the evening, my Lord. I am to file the affidavit. So, my Lord, I might be kindly given 1 week's time, my Lord, to file my affidavit.
So the posts have been created.
Yes, my Lord. Temporary, this post has been created on temporary basis. So there are some steps taken by the state, my Lord.
Then she can get the post of chairman or chairman.
Okay, we'll give you 4 weeks time.
Obliged, my Lord.
What, do you want 6 weeks? Mr.
Benjamin Lathamana,
Benjamin Lalsaman, Learned Counsel for the
state respondent.
first state respondent, is granted 4 weeks time to file his affidavit, comma, in as much as he submits that he has received the para-wise comments today. Yesterday.
Yesterday.
List the matter after 4 weeks.
Item number 2.
Obliged, my Lord.
Obliged, Lordship. Yes, my lord. If the matter may be listed after 2 weeks, since
Why?
I'm having some eye infection, my lord, from yesterday, since yesterday, so I couldn't read anything.
This is regarding the cess.
Yes, my lord.
What is the provision of law which allows the state government to take cess?
As per in new insertion, my lord,
Huh?
section 75.
Section 75. Which page?
So if there is a last page, it starts at 99. Last lecture. This amendment came into effect on 23/9.
It is in page 101, my lord.
Share of government.
In terms of that section 4, subsection 4, last page, sir, the notification has come. 23/11/2022 with effect from 23/9/2022. Clause 8. And the award was of 17/2/2023.
Okay, we'll adjourn the matter. On the prayer for adjournment made by Ms. Vande Siami, who submits that she is having some eye problem. This is the matter after
2 weeks.
2 weeks.
Obliged.
For orders, item number 3.
Should they not be required to challenge that? They have to be following the
My lords, I am praying on behalf of Mr.
I think you might have to challenge the
earlier one.
notification.
Burning sir.
Yes.
Yes, my lords, I am standing on behalf
Who is
of
appearing for the other side? You are appearing. For whom?
My lord, I'm for the private respondent.
Private respondents.
Yes.
Okay, you see, the issue here, this is a condonation of delay application. You see, the issue here is basically the fact that the road has been constructed and they have said that they have not touched your land. So, if they have not touched your land, where is the question of acquisition?
At the time of the writ petition, my lord, there was no such affirmance made by the
No. But then if it is a question of fact, the question of fact can be gone into. It is not a question of there being any technical issue here. It is an issue of whether the road has touched your land or destroyed your land or gone through your land. If it has not, then there is nothing. You can claim damages, but you cannot force them to acquire your land. They might have made a mistake in making your land a part of the award. But if they say that there is nothing here, then what remains?
And my lord,
So I think we will allow the condonation. We will examine that aspect. We will give you time to examine that aspect as to whether your land has been touched or not by the construction of the road. That's all. I think that's
the only issue.
my lord, regarding this delay, we were not given chance to
No.
object.
You see, forget about the delay. The single judge did not even allow no one represented the government of India, no one represented the NHIDCL. That judgment is also wrong.
NHIDCL was represented, my
But
lord.
it is not
in the-
reflected in the
in the
order.
judgment.
The order does not say that. You see, you come to page 18.
We are not given copy of the appeal, my lord.
No, I've got. So we are not touching the appeal.
Yes.
We are not touching the appeal. We are only touching upon the issue of the condonation of delay. We will see because out here, advocate for the petitioner, Mr. So-and-so, advocate for the respondent, additional AGGA Mizoram for respondents number 1 to 3. While there were 8 respondents, 4 is Kala, 5 is Union of India, 5 and 6, 7 is NHIDCL.
Yes.
They were not a party. Nowhere is it reflected.
My lord, it was in the writ petition, there was, council was represented by, 7 and 8 was represented by Mr. Samuel in the writ petition, my lord.
Same order.
Okay. Okay. But this thing is not here. NHIDCL is not here.
NHIDCL?
They are the contractor.
That is not there.
The NHIDCL is not there. They are the contractor. They are the one who constructed the
7
road.
and 8. No, sir, 7 and 8 was there. Samuel 1.
Achha, 7 and 8. They are there.
Sir, if you come to the opening paragraph, parties are represented by the
Except for respondent number, Kala is not there.
Only Kala was.
So, why is it 2 orders, same orders, 2 different orders on same date? One is 1611.
1611 is the first order in the,
Both are 1611. Page 18 is 1611. Page 26 also is 1611.
This is a downloaded copy, sir. This is the certified copy.
the final order is page 24, my lord, 25, starting from 25.
No, whatever it is the same order.
Yes.
In one order of the same date, it shows only respondents 1 to 3 are represented. In the same order of the different page 24, it shows that everyone is represented, except for 4. 4 has not been represented. Anyway, I think we'll allow the condonation. Then we can look at the main issue. It's a very small issue. If the road has touched your land, you are entitled to get compensation. If it doesn't touch your land, you can claim damages. You cannot force them to acquire. Right. Heard Miss Lalam Dwati Rentle, learned counsel for the applicant. Also heard Mr.
Saudin Sanga,
Aizodin Sanga, learned counsel for
private respondent.
private respondent number.
One.
Private respondent number 1. Mr.
Benjamin Lathamwana,
Benjamin Lazaman appears for respondent number
234.
234. This is an application for condonation of delay of 359 days in filing an appeal against the
16.
order dated 16/11/23 passed in WPC 104/2023, by which the respondent number 5, I think, no? Respondent number 5 has been directed to make an appropriate assessment for the value of the land for the petitioner which was affected due to construction work. Thereupon, the respondent number 4 was to forward the same to the respondents number 6 to
No, here would be the applicants.
yes, it would be to the applicants, to the applicants who are to deposit the assessed amount for onward disbursement to the respondent number 1. Full stop. The case of the applicants, on the other hand, is that the construction of the road has been completed and the same has not touched the land of the petition of the respondent number 1. Full stop. The counsel for the applicant submits that the delay in 353 in filing the appeal has been caused due to has been caused due to the time taken for being furnished a certified true copy of the impugned order dated 16/11/2024, which was applied on 26/11/2024 and issued on 29/11/24. Full stop. Thereafter, some correction was carried out in the memo of the appeal, which was prepared, which resulted in there being a delay in filing the appeal, amounting to 359 days. Full stop. The delay in filing the appeal was due to the clarifications sought for by letter dated 13/12/2023 by the Project Monitoring Unit, Lungle, from the competent authority Kala, CALA, Deputy Commissioner, Serchip District, with regard to the land documents of the respondent number 1. Full stop. As Kala did not respond immediately to the request, the project monitoring unit at Lungle don't say that. The number of days were lost. Full stop.
12, sir. Page 12. They had filed an appeal earlier, and that was withdrawn, sir.
Okay. The applicants had also filed WA number 13 of 2024 in respect of the impugned order on 21/6/2024, and the same was listed on 19/11/2024. However, due to the some technical error in the memo of appeal, the writ appeal was allowed to be withdrawn with liberty to file afresh by order dated 19/11/2024. The applicant thus praised that where is that withdrawal order?
Yes, your order. Page 23.
Oh, it is me. Okay. As due to the above reasons, a delay of 359 days has occurred. Full stop. Mr. Abdul Sanga, learned counsel for the respondent number 1, submits that no day-to-day explanation has been given by the applicant in filing the present appeal, and as such, there is no sufficient cause has been made out for condoning the delay. Full stop. We have seen the reasons for the delay and the fact that the applicant had earlier filed WA number 104, 13 of 2024 against the impugned order passed in WPC number 104 of 2023. Full stop. WA number 13 of 2023 had been allowed to be withdrawn while order dated 19/11/2024. Full stop. The present appeal has thereafter been filed within 28 days from the date of from the date of the applicant being allowed to withdraw WA number 13 of 2024 with liberty to file the appeal afresh. Full stop. In that view of the matter, we are of the view that sufficient cause for the delay in filing the appeal has been made out. The above being said, the facts as stated by the grounds for the appeal as stated by the applicant's counsel leads us to believe that if refusal to condone the delay, if the application for condonation of delay is refused, the same could cause grave miscarriage of justice. Full stop. The same would not be in consonance with the judgment of the Supreme Court in the case of State of Nagaland versus Lipokau. Then, in view of the reasons stated above, the delay of 359 days is condoned. I is accordingly allowed and disposed of. Then, in the main case, right, heard Miss
Larimrati Rentley.
Larimrati Rentley, learned counsel for the appellant, who submits that the impugned order dated 16/11/2023 passed in WPC number 104 of 2023, directing the respondent number 5 to make assessment with regard to the payment of compensation to be made to the respondent number 1 for construction of a road on the land of the respondent number 1 should be set aside. She submits that the road that has been constructed does not touch the land of the respondent number 1. Full stop. Admit the appeal.
My lord, a copy of the appeal may be.
Okay. Anyway, in the meantime, we're not disposing it off.
Yes, yes.
Admit the appeal. Mr. H. Zodin Sang accepts notice on behalf of respondent number 1, while Mr. Benjamin Lalsamona accepts notice on behalf of the. Where is CGC?
345.
345. Where is CGC? Ms. Zaidam Sangpui, CGC accepts notice on behalf of respondents number
6 and 7.
6 and 7. Petition appellant to take steps for service of notice upon the respondent number 5 by registered post with AD within 3 days. Extra copies of the writ petition should be provided to the counsel for the respondent number 1 within 2 days. This is the matter after
2 weeks, my lord.
2 weeks.
Item number 4.
The impugned order shall remain stayed till the next date.
Lordship, this is an application for condition of 57 days delay.
What to do? No one has appeared, and then 1 month has not elapsed.
Yeah, shall we wait for some time?
So we'll await service report. Okay, wait. Right, Mr. C. Zoram Chana appears for the applicant. No one appears for the respondents. The office note indicates that notice was issued to the respondents number 1 and 2 on 18/2/2025. First off, there is no return of AD card or unserved notice from the respondents till date. Await service report. This is the matter after 2
One
weeks.
week, my lord.
2 weeks.
Item number 5.
was implemented.
Yeah?
Government of India was implemented jail reforms. They want to implement the Secretary Finance expenditure. Government of India as a party correspondent number 7.
Probably for the money.
Money.
Yes, why do you want to implement this?
Ministry of Finance, Lordship.
Why?
Lordship, we have implemented the Ministry of Finance because they are the nodal department for overseeing the public financial management in the central government as well as matters connected with the state finances.
What is their role? Their role is, you see,
Especially
there is the reconstruction of the jails is
Yes,
for
Lordship.
55 crores, correct?
Yes, Lordship.
Has the money been provided?
No, Lordship.
Money has not been provided.
No, Lordship.
Then where does that magic figure of 55 crores come into the picture? That is going to be provided by the state.
Yes, Lordship, from Saski scheme, which was
Yes, madam.
reflected in the...
Who is going to provide the 55 crores?
My lord, this application my referent have submitted was with the advice of this coordinate bench, my lord, in the last 4 days. Even it might not be reflected in the order, my lord.
Still no.
Yes, Lordship, as per order
That is
dated
different.
19/2/2025.
19 to 20.
Sir, 11/12/2024. 11/12/2024. So and so pays for central government. Then that was done in 15 months. 15 months. After that, I didn't find any order.
Can we force the central government to give the money? This is a state jail.
Yes, Lordship.
The state will have to find ways and means to get the money. You cannot force the central government that you have to provide.
Yes, Lordship.
You see, at the first instance, has the state government asked this particular office or ministry for the money? Have you asked for the money, madam?
My lord, I'm not very thorough with the case because this matter is handled by...
For 4 projects, upgradation, renovation, central jail, construction of so-and-so construction, DPR, alumni was submitted to the government.
The Ministry of Donor.
Donor, okay. Ministry of Donor, Military Finance.
Not the money.
And these will be under the budget of that department concerned.
This is their issue, but then you see one thing. Which page was that you were reading?
So page, this is the addition, affidavit by the state, response number 3, 18/8/2024, serial number 6.
18/8/2024. You see, this affidavit, 18 August 2024, submitted by the respondent number 3, Chairman, Secretary, Planning, Program and Implementation, okay,
Yes, Lordship.
Government of Mizoram, speaks of this project cost being asked for from the Ministry of Donor. Where is that?
So page 3.
Come to page 3, para 2b.
Yes, Lordship, I'm on it.
Please read.
That thereafter the government of Mizoram has
No,
taken...
2b.
I'm on 2B, Lordship.
Yes, that DPR of it. This is the affidavit submitted by Vanlal Ava, Shri Vanlal Ava, age 58 years, working as Under Secretary to the Government of Mizoram in the Planning and Program Implementation Department. You don't have it? Affidavit of, it will be It will be 18th August 2023. You take this. You take this. Yes. No, it's okay. Just wait.
There are so many affidavits submitted already, Lordship.
Just see paragraph 2B.
Yes, paragraph 2B, that DPR of 4 project proposals, 1 upgradation and renovation of central jail Aizawl costing rupees 100 crore, 2 construction of district jail Saiha consisting of rupees 50 crore, 3 construction of district jail Champhai costing rupees 59.128 crore, number 4 construction of district jail Lunglei costing rupees 52.40 crore have been submitted to Ministry of Donor via this department's letter so and so, dated 17/11/2021. Response from the ministry is being awaited.
So they have. So the government of Mizoram, in this affidavit, they have said that it has been sent to the Ministry of Donor.
Yes, Lordship, and in their next affidavit on dated 4th December 2024, Annexure 1. This is from the Saski investment 2024 to 2025.
Affidavit dated?
Dated 4th December 2024.
Yes.
After 18th of August 2023, they have submitted another affidavit stating that they have lost hope from donor and it's going to be taken up by the Saski.
This is basically a issue between the central government and the state government. This is the state government. It is the duty of the state government to look after their own jails.
Yes, Lordship.
From where they get their money is their issue. Why should we come between them? Is it our job to come in between them and that we must say the central government has to provide? Can we say that?
No, Lordship.
That affidavit. Paragraph E and F.
And the annexure dated 2nd September 2024, it's written that it's under demand number 16, name of department home. I have gone through all the demands. It consisted around 568 pages.
So these Saski funds have not been released. Madam J, Saski funds have not been released as on date.
My lord, I will have to obtain instructions in the matter, my lord.
Okay, we'll implement them. How does it matter? Okay, we'll implement. Right. I heard Miss Rosalind Nelfa, learned counsel for the applicant. You see, madam, one thing, your application, you see, your prayer, if you look at your prayer is like this. Please read your prayer.
In the premises aforementioned, it is most humbly prayed that your Lordship may graciously be pleased to admit this application and issue notice calling upon the respondents to show cause as to why the instant application should not be granted. And after hearing the parties and show cause by both parties to implead, respondent number 7 in PIL 3 of 2022.
Who implead respondent number 7? Who? We have got to implead someone as respondent number 7.
Yes.
Okay, right. Ms. Rosalind Elvan, learned counsel for the applicant. who submits that and you see, you come to para 2, madam, this is not the way.
Para 2.
You have to write the secretary to the government of India.
Yes, Lordship.
Ministry of Finance.
Ministry of Finance, Department of Expenditure. It has to be that way. This is not the right way of writing. This is wrong. You see, I'll just tell you, for example,
Yes, Lordship.
in the government of India, there is a Ministry of Commerce. Ministry of Commerce consists of two departments. One is Department of Commerce and one is Department of Supply. So even in the finance, there can be two or three secretaries also. So they are different. So you have to say secretary to the government of Government of India, Ministry of Finance, Department of Expenditure.
Yes,
You don't say Secretary, Department of Expenditure.
Yes, Lordship.
Okay, right. What to do? We have to correct this. Yes, what have we said? Submits that, praise that. Praise that or praise that? Who submits that? The Secretary to the Government of India, Ministry of Finance, Department of Expenditure, room number 129-A, North Block, New Delhi, PIN 110001, should be implemented as respondent number 7. Who is for the other side? Miss Mary L. Kiante. GA submits that she has got no objection to the application being allowed. Accordingly, the Secretary to the Government of India, is implemented as respondent number 7. Applicant shall submit a corrected cost title with the registry within 5 days. I is accordingly allowed and disposed of. Now in the main appeal, in the main writ petition, you just write, in view of the order dated 12/3/2025, passed in IAC 43 of 2025, the Secretary to the Government of India, so and so, is implemented as respondent number 7. Issue notice to the respondent number 7. Ms. Zairem Sangpui CGC accepts notice on behalf of the respondent number 7. Applicant to take steps, applicant to serve extra copies, writ petitioner to serve extra copies of the writ petition to the CGC.
Obliged, Lordship.
Amended cost title in terms of your order, so that means the order, not in the petition.
Okay. Then we have said somewhere that we have said that in the IA, I think we have asked the applicant to serve a corrected cost title to the registry in terms of the particulars mentioned in this order and not as per the application.
Obliged, Lordship.
This is the matter after
2 weeks.
2 weeks.
Supplementary cost list, item number 8.
The signature in the agreement at page 16 and the signature here is not same at all.
Which one? Page 16 and
Your affidavit of service. The signature of Jacob Lalpe Klua does not seem to be the same.
yes, Lordship, in page number 16, someone put signature
For
for in the name of him.
whom? Him means whom?
Dấu Xiêm Liên.
That much I know, but Jacob's signature, look at Jacob's signature, page 16.
We don't know, sir. That affidavit we forward it. I mean, by way of Dusty, we send it and they deliver it. I don't know what happened to the signature.
If you don't know what happened, who filed this affidavit?
Affidavit is filed by me.
Then how can you file the affidavit if you don't know anything?
However, the Dusty was served by the civil money suit, the party. I mean that the council of the money suit from Longley, they served it.
Who's your senior? Have you got any senior?
Not now, Lordship. In Longley, the case was taken up by Mr. Manuna. So he served the copy. Dusty.
This Josiam Lena's signature is some C. Julie. Who is this Julie?
Julie is, like I said, Lordship, the council of the council junior intern.
Junior of which council? Council's name is who?
The council in Manishur.
What is the name of the council? Name?
Manuna Junior.
What is to be done? This case though has to be allowed. That much it can be seen from the facts. Has notice been served? Just look at the file. So execution case has been stayed.
Yes, Lordship.
No, where is the AD card? Is there any return of AD card, postal report, nothing? Postal report is here. Okay, anyway, right. What have I said? No one appears for that. Full stop. On the other hand, notice by a registered post with AD had been issued by the registry for the respondent on 2/7/2024. However, there is no return of AD card or unserved notice. Full stop. This court has, next para, this court has also noticed that, continue. This court has also noticed that the operation of the execution case number 24 of 2023 for execution of the settlement dated 11/9/2021 pursuant to the made settlement dated transfer made before the National Lok Adalat Lungle. No, before, not before, at the National Lok Adalat Lungle had been stayed. Wide order dated 20/08/2024. So this still stayed.
Yes, Lordship.
However, despite the same, no one appears for the respondent. This court is of the view that as 30 days have elapsed, and as thus the service of notice has been made on the respondent, notice is served upon the respondent. Notice deemed to be served upon the respondent. Full stop. As no one appears for the respondent, the matter is being decided ex parte. Full stop. Next para. The petitioner's grievance is that the respondent had the respondent had filed a money suit number 48 of 2019 before the court of the Senior Civil Judge Lungle for recovery of rupees 9,75,000 from the petitioner, which had been taken on loan. The petitioner had accordingly deposited his land documents.
Yes.
Land document, that is LSC number 166 of 1996. As security for the loan amount.
Yes.
With the respondent.
Yes.
Correct?
Yes, that's true.
Full stop. The money suit was thereafter sent to the Lok Adalat Lungle for attempting a settlement between the parties. Next para. The petitioner's counsel submits that a settlement award had been issued, settlement award dated 11/9/2021 was issued by the Lok Adalat held on 11/9/2021, wherein it was agreed that the petitioner would pay an amount of rupees 7 lakhs to the respondent within 6 months. Thereafter, LSC number 166 of 1996 was to be returned by the respondent to the petitioner. Next para. The petition's counsel submits that the settlement award dated 11/9/2021 has been submitted to the court of the Senior Civil Judge Lungle for execution.
Yes, that's it.
While execution case number
24 or 23.
24 of 2023. Full stop. the petitioner's counsel submits that the settlement award had not been signed by the petitioner and the same was done by the junior counsel of the petitioner's counsel.
ZD Lal Nunsanga.
That is, what is the lady's name?
ZD Lal Nunsanga.
No, lady.
Julie, C. Julie.
C. Julie. Huh?
C. Julie Mal Somdong Zeli.
C. Julie Mal Somdong Liani, who was the junior of
ZD Lal Nunsanga.
ZD Lal Nunsanga. Full stop. He accordingly praised that as the settlement award had not been signed by the petitioner, and as the same had not been done as with the consent of the petitioner,
Yes, yes.
the settlement award dated 11/9/2021 should be set aside. Correct?
Yes, Lordship.
I have heard the learned counsels for the parties. A perusal of the settlement award dated 11/9/2021 shows that C. Julie, C. Julie, has signed on behalf of the petitioner, that is Zosiam Liana. The above clearly shows that the petitioner had not given any signature to the settlement award. There is also no document to show that the petitioner had given his consent to his counsels to sign the settlement award on his behalf, or that he had agreed to the terms of the settlement award. An affidavit dated 26/6/2024, executed by the counsel for the petitioner in the district court Lungle, that is Shri ZD Lal Nunsanga, has stated that he had not directed his junior, Miss C. Julie Lalmal Somdong Zeli, to put her signature in any paper before the Lok Adalat, as she was not authorized by the petitioner. However, C. Julie Mal Somdong Zoli was forced by the members of the Lok Adalat to put her signature on behalf of the petitioner. Be that as it may, the fact remains that no, sir. Notwithstanding the above fact, this court finds that the petitioner was not present at the Lok Adalat on 19 11/9/2021, and neither did he put his signature on the settlement award. Full stop. Next para. In the case of State of Punjab and another versus Jaloor Singh and others, Jalour, Singh and others, 2008, 2 SCC 660. The Supreme Court has held that where an award is made by the Lok Adalat in terms of a settlement arrived at between the parties, bracket, which is duly signed by the parties and annexed to the award of the Lok Adalat, comma, it becomes final and binding on the parties to the settlement and becomes executable as if it is a decree of a civil court and no appeal lies against it to any court. Full stop. If any party wants to challenge such an award based on settlement, it can only be done by filing a writ petition, a petition under Article 226 and /or Article 227 of the Constitution, comma, that too on very limited grounds. Full stop. But where no compromise or settlement is signed by the parties and the order of the Lok Adalat does not refer to any settlement, comma, but directs the respondent to either make payment if it agrees to the order or approach the High Court for disposal of merits, of the appeal on merits, if it does not agree, comma, is not an award of the Lok Adalat. The Supreme Court has thus held that unless a settlement has been made, an award passed in terms of a settlement or compromise, required under section 20 bracket 3 of the Legal Services Authorities Act, 1987, such an order cannot be said to be the award of a Lok Adalat, as it has been made contrary to law and beyond the power and jurisdiction of the Lok Adalat. Such awards made in the absence of any settlement would be void in the eyes of law. Full stop. Next para. In the present case, there is nothing to show that any settlement had been made between the parties and signed by the parties, on the basis of which the award dated 11/9 or 9/11.
2021.
Huh?
2021. 11/9/2021.
11/9/2021 could have been issued. Further, the award dated 11/9/2021 also does not contain the signature of the petitioner, and in fact contains the signature of one C. Julie over the name Zhou Lian Sanga. Zhou Xiam Lian.
Zhou Xiam
Lian. Full stop. In that view of the matter, the award dated 11/9/2021 having been made in violation of section 20(3) of the Legal Services Authority Act 1987, the same is void, and same is void, full stop. The impugned award is accordingly set aside. The matter is remanded back to the Lok Adalat, Lungle, who shall attempt a compromise afresh. Full stop. If no compromise is forthcoming, the matter may be remanded back to the learned trial court. The writ petition is accordingly allowed and disposed of. Allowed. No point keeping it pending, this matter. If they want, they can file an appeal. They can file a review also.
Obliged, my lord.
Touch me, the book to